I request Magic Committee member Ajay Talreja to escort today's speaker, Advocate C.V. Thakar sir, to the dais. I request Chairman of the Alienor Committee, Shri Dinesh Tamre, to join the dais. Now I request President sir to, I hand over the proceeding to President sir for the announcement.
Good afternoon, respected today's speaker, C.V. Thakar sir, committee chairman, Dinesh Tamre, my office bearers, Parth Badeka, treasurer, joint secretary, Vinod Maske, Jatin Cheda, all my past president present over here, Deepak Thakar sir, Sujata madam, Ashwin Acharya ji, all senior members and friends. Before we start the lectures, this week we have lost our two senior members of our associations, Mr. Satish Bansali sir, who has always attend our RRC and all the events, even this study circle he has attended. And second one is a Pramod Zambekar from Sindhudurga. He is also senior member. I request all of you to please stand for 2 minutes for condemnation. Om Shanti. I, on behalf of GSTPAM, welcome you all on second study circle meeting of GSTPAM of the year 2023-24. Today's topic is we have decided this topic because of lots of members from outstation and from Mumbai on this topic 16.4. Immediately I called Thakar sir. Sir, this is the topic you and this topic is particularly on judgment, important judgment of 16.4, and he readily accepted this for this subject. I thank you, Thakar sir. Thakar sir is always cool and calm person. He is always available for the GSTPAM and all the activities of the GSTPAM. Thank you, Thakar sir. We have also planned to start our coaching class in Marathi language and Gujarati language in the month of October immediately. Marathi and Gujarati. Then we have planned to organize half-day seminar at Malad on 13th October 2023. Yesterday only our chairman, under the leadership of chairman Dinesh Tamre and both the conveners Aditya Surte and Sunil Joshi had filed the representation on the PT and VAT amnesty and extension of due date for Satara district. And there were the collector has passed the GR. There are no network in that district. That's why we have filed this representation. Marathi and Gujarati coaching class, I request all the members and your senior or of your juniors kindly enroll for the same. And thank you once again, CB sir, for accepting our invitation for this lecture. Thank you. Thank you.
Thank you. Thank you. Thank you, President sir. Now I formally introduce today's speaker, Advocate C.B. Thakar sir. I think his name doesn't need any introduction, but for the benefit of the new journers, I am just reintroducing to the forum. C.B. Thakar sir, born in Vankane, Gujarat. He has passed his CA in the year 1982. He has passed his LLB in the year 1983. He has practiced as a chartered accountant from year 1983 to 2004, and now he is practicing as an advocate. He has actively involved for the education activities. He has submitted papers and delivered lectures on the sales tax and various seminars, conferences for tax practitioners, students, and beginners in the practice. Conducted by ICAI, Sales Tax Association of Maharashtra, various regional practitioner associations, and other social organizations like Lions Club, Rotary Club, etc. He was the president of our esteemed association in the year 95-96. He was past president of Sales Tax Tribunal Bar Association for the year 2006 to 2008. He is a regular contributor to the articles in the magazines published by BCA, All India Federation of Tax Practitioners, newsletter published by Western India Regional Council of Institute of Chartered Accountants of India, Sales Tax Review published by GSTPAM. He was the chief auditor of Sales Tax Review in our prestigious magazine. He authored a study material for beginners in the sales tax law in Maharashtra for Western India Regional Council of ICAI. He was a member of Publishing Committee of Guidebook in VAT Audit under the Maharashtra Value Added Tax Act 2002 and Issues on VAT Audit published by Western India Regional Council of ICAI. He has co-authored a study material on Central Sales Tax Act for the Institute of Chartered Accountants of India, New Delhi. He has co-opted as a member to Research Committee of the Central Council of the Institute of Chartered Accountants of India for the year 2002-2003. He was co-opted member of Research Publication Committee of WIRC of ICAI for the year 2019. With this brief introduction, I present before you today's speaker. Now I request our president to felicitate sir with the memento. Just before starting the lecture, I request our chairman, Sri Dinesh Tambe sir, to give some remark regarding study circle activity.
I do not want to speak anything as we all have gathered to listen CB sir. When we decided the subject, President asked me as to whom we should call. We should call any High Court advocate because there are so many complicated judgments are coming and this issue is going on regarding disallowance of ITC. I said I have also started High Court practice. We have so many High Court advocates in our association because in day in, day out, the practitioners are facing problem. For that, to whom we call our seniors. And for speaking here, we should call some advocate from High Court. Do we think that our seniors are not efficient enough to guide us? So we decided there's no other person fit for this subject other than Mr. C.B. Thakar. So welcome, sir, and thank you for accepting our invitation.
President of our association, Pravinji, all my friends. It is normally now study circle meetings have also become a time has come where it should be hold on online, I think, because people previously it was a time when these walls used to be very full, whatever may be the subject and whoever may be the speaker. But that because of the change in scenario, work from office as well as possible due to internet and all. The time has changed and we have to accept that. But still our committee, as I was discussing with the office bearers, they said now we'll continue with this practice by which at least those who are coming we should not deprive. That is first thing. And secondly, interaction, whatever is possible, will continue. So friends, today I have to speak with topic of ITC vis-a-vis section 16(4) and mismatch. Now friends, we are aware that why the scheme of ITC is there, everybody is aware. It should be with the view that there should not be cascading effect. Whatever you have paid while purchasing, you should not be again liable to pay the same amount to the government with all collection from the buyer. Otherwise, it will multiplication and certainly, definitely more than the price tax will be higher when it goes to 2-3 stages up to consumer. So it is a scheme evolved right from BST era or prior to that also it may be there. But the days were good by one sense, in the sense in BST era there was no computerized comparison, only based on paper information from here and there. They used to say that something is wrongly taken by you, etc. There are no cases about set-off disallowance, hardly few cases, mostly they were other than set-off cases in appeals, etc. Now you find that number of cases are only based on these ITC issues and very few cases on other legal issues. So that is how the things are changing. Now, when you go to ITC or set-off, it is always considered that when I have paid to my supplier, I am out of pocket, so I must get it, whether my supplier paid it or not, whether it is filed return or not, whether it is available or not. That is what our patent arguments. And this matter has been tested in various courts, including Supreme Court. And everybody is saying that this is not your constitutional right. This is the statutory right given by the statute or by the act. And that is why you cannot say that not disallowing in particular circumstances is a breach of law or breach of constitution or unconstitutional. And that's why they say that you have to abide by conditions. So now that is the primary thing which you have to keep in mind. In the courts, when you go, you can never challenge it based on constitutional provision, Article 14, 19, vagara, vagara. That is very difficult now. So what you have to do? You have to find out the faults within the act and loopholes available, that in spite of this, I am still available because of this situation. That is how we have to prove within the act section. We have to say that I am entitled in spite of what they have pointed out wrong or right. So friends, this is how the case laws are coming up. And abiding by conditions as per all judgments till today. There is not a single judgment, including our landmark Mahalakshmi judgment and the VAT era. Everybody has upheld that yes, it is a conditions can be prescribed by the government. And if you are failing to do, in spite of you have paid to your supplier, you cannot claim set off and you have to bear it again. So this is the things which you are going to be happening in future. Now coming to GST, our section 16 of the GST Act is the prime section which grants or provides for grant of ITC. And most of the things are covered in that section itself. So what are the just salient features when we go to section 16.4? What will be happening prior to that? So we have to start with section 16. First of all, the condition is that inward to be in the course or furtherance of business. So if something is proved by the officers that it is not for furtherance of business or in course of business, for example, your household expenditure, you cannot claim it as ITC. So to prove that is your duty when you claim it. There may be number of situations where probably they may say that is not your business expenditure. For example, if you purchase mobile, this I am just giving example. I may not be correct in that, but what has come to my mind. Or you have made certain expenses, and in income tax, previously when there were scrutiny assessment, they used to disallow something on estimation basis. For example, 1/3 of telephone expenses, 1/3 of tea expenses. So if these are disallowed, probably that can be said to be not in course of business. So that will have effect even under GST also. If somebody goes minutely, that this expenditure you have claimed is not allowed as expenditure under business head in income tax. That is why it is also not business expenditure. I'm just giving an example. It is all facts of the case. Everybody can prove that in spite of whatever disallowed there, still I am entitled, vagara, vagara. So first hurdle we have to cross is it should be proved in the course of business. Another is that you should be in possession of tax invoice or document. They have specified two things, tax invoice and documents. So you must have tax invoice from the issued by the supplier to claim the ITC, and document may include your bill of entry. For example, you have paid IGST or other any debit note, etc., etc. So this is what you have to have in your possession. And when we read the cases under GST, they are very much particular about all these issues now. Under VAT, etc., we find that even at the time of assessment also you can produce the invoice. But now when you are going for visits, for example, investigation visit, they are immediately catching you up if the bills are not available in your file. Even if they are kept at some other place, that also is considered as your offense. Why not available at this place? So now they are harping upon all these issues. We have to educate our dealers that whatever place of business you have declared, at that place they should be available. And if they are kept somewhere else, you see that that place is also registered as additional POB, or you can keep copies there and documents here, or original here, something like that. Then declaration and communication of tax invoice as per section 37, that is now GSTR 2B. So we have that supplier must show it into that. It is now invoice wise matching they are doing. So very difficult if 11th date is gone and you are not uploaded GSTR 1, that is not reflected in your 2B. This is the, we are getting complaints. If you are filing returns, you should be more careful, because I remember one case where you are supposed somebody's office forgot to include one or to file the return on that 11th day because of some issues, and it got filed on 12th and 13th. Now that's purchaser say that because it is not shown in my GSTR 2B on 11, I am not able to take the ITC of that. So you give now interest of 1 month to me because I lost for 1 month that ITC credit. Dinesh, is it okay? Because if you are not shown in this month, 11, it will get reflected now. Suppose you file on 12, it will go into next month 2B. So 1 month, they will not able to take credit. So that is how complaints are coming from the buyers. And you have to, because unnecessary professionals are being involved into this. Because if your office is filing, they say that it's a mistake on your part, now we will bear this and that. So friends, more and more compliance burden upon the professionals. Then next condition they have put is that the goods and services are received. But this again onerous. Now there are number of things they are asking for. You have received the goods, like transportation is most they say that LR, lorry receipt. Without a lorry receipt, they are not agreeing or not ready to agree that it is a purchase by you or goods are received by you. Now, according to me, this is not a criteria to decide whether goods are received or not. It can be received by hand card. They can be caught physically also. It is depends on the nature of goods, and there may be constructed delivery also by way of delivery chalavan, and the goods are lying in the godown of the supplier. Possible. So all these factors, but practically people are making difficult. And in Supreme Court also, in one case in relation to set off under Karnataka, they say that without moving, showing the movement of goods, there is no purchase. So all this, they, of course, that is depend upon the facts, but Supreme Court has observed like that. So these are some of the judgments which will give more issues to the department, and that is how difficulties will arise. Now, wherever possible, you should advise that you keep the transportation proof. If suppose it is by other than LR, you should show your expenditure of our transportation in your books of account, make a voucher of that, write the name, who has brought and what you have paid to him. Like something like that, you must preserve according to me nowadays. Even they are out, even if your business is 100 crores, they will find out mistake for 1 crore. 99 crores they have find okay, but 1 crore there is no, will disallow that much. So this is how they are going minutely in the audits and etc. GST audit. Now we can understand about goods, some tangible proof can be brought. But what about, I don't think e-way bill is a conclusive proof of, it is only a proof in the sense it is generated that these goods have to be moved from by this vehicle also. Now they are tracking it on the road, that toll nakas also, whether that vehicle has passed there or not. So this is also one more issue. But I don't think e-way bill, maybe you can say that e-way bill is available, but that will not solve your problem unless you have got a physical LR for that.
There is a violation in terms of e-way bill. Can my subsidized transaction be negated for that?
I don't. E-way bill transition or some breach in e-way bill provisions, you can have invite penalty for that. But you cannot negate your transaction. Definitely not. But if you are e-way bill but no LR, probably problem will arise. That it may be made out because that doesn't require any tangible proof by preparing the I think e-way bill. It is simply you put the lorry number and it will generate it. Now sometimes they are finding that what lorry number return is of the scooter and bike and all that. Rickshaw. So now at least that Vahan.com, they are checking and finding out those issues. Toll, yeah. Whether that has passed through toll naka or not. So all that new instruments are available with them, and accordingly now we have to see that. No, I think they are capturing that on the video photo, no? Okay. So if you pay by cash, you mean to say it is not reflected in the. There you have circular loops, yeah. But that means you have to prove on facts. But ये सब उनके पास भी machinery available हो गया, so they are going to create capital out of it. Now, how to genuineness we have to prove. Without this, also that can be seen, no doubt about it. But they are now not relying upon your words. I remember one case, Voltas Limited in Bihar. They have got some issue about e-way bill was not correctly made, etc. And the penalty was levied. They went to High Court, and what they said, sir, we are a prestigious company, and no offense has been ever found in our cases. High Court said, Baba, we don't know whether you are a prestigious company or known company. This is the offense, and you have to suffer the penalty. So now, relying upon good atmosphere, or you are regularly filing returns, or you have been there in that existence for 50 years, will not work. You have to be with documents. And what about services? How to prove I have received services? They are raising a lot of issues. Now in insurance companies, that payment have been made to agents, etc. And now they are raising 1,000 crore, something is going on. And agents, they are taking statement that we have only asked to give the bills, and they have given the checks, and etc. etc. So that make issue arise in anybody's case. When you say that I have taken a bill from chartered accountant, what services you have rendered? Just an example I am giving. So this is how services, how can you say that I have received? It is only, it can be by bill only, repair service. Now we'll come, repair and give a bill. What type of proof we can have that I have received services? Consulting. Right. But now they will say it is a fake bill. They do. So what you should do? आप एक ऐसा वीडियो निकालने का, जब वो आता है तभी उसका वीडियो लो, काम करता है तभी वीडियो लो, कॉपी वॉपी पहना के लो, हाँ, फिर उसका एफिडेविट ले लो, भाई मैं आया था, काम सब करके गया, उसके बाद उसको भेजो वापस. So this is regarding services. Really is a. I think if they don't find anything, they put on this also. Manpower services. And they are also asking for repair, etc. But depends. But they are doubting all service bills now. Then, friends, new conditions have been inserted. That is, ITC is not restricted under Section 38. That supplier has not filed returns and all that things are being on. This is on the portal itself. They are restricting. So you have to be seen about that. Then, payment of tax on such supply by supplier. See, language used in our section 16(2)(c) different from 48(5). 48(5) saying that you should not exceed more than tax paid on the same goods. So even if my supplier has not paid, but my earlier supplier has paid, we can get still ITC if I prove that those are the same goods. And tribunal has granted in number of cases. When I prove that there is one case where Talati Sahab was there, there was an imported machinery. Importer has paid tax and sold to somebody. Somebody has sold to somebody, and that somebody was from that Rajat Talati's client has purchased, and that fellow was declared as a Hawala. So department disallowed the set off based on that this is our purchase from Hawala. But when the link was proved that is the imported one, already tax is paid on that, and this is in between dealers, and one of them has become Hawala, still the tribunal granted them set off. So that was how the language was, tax paid on the same goods. But if you go to section 16(2)(c), yeah.
most of the time we find that in this kind of cases, investigations, they take the statements, adverse statements on record of agents or the
Service provider.
service providers, they take adverse statement, maybe by coercive means they take those statements. Can we take the counter affidavits of those people whose statements, adverse statements are there on the record for the benefit of our client? Is it advisable? Because they are into business with the client day in, day out. But when they appear before the authorities,
Of course, they have taken them
the
and
investigating authorities, they record the statement under the fear. So, how is it advisable to take the counter affidavits?
so certainly, as early as possible, you can take and put it on the record of the department that this was.
Thereafter, they record another statement that counter affidavit had been given under duration, because we can't force the third party department can force, but we can't force. But they thereafter
They again,
record
you mean to
another
say then
statement,
again,
statement they record.
but then you got to ask for personal cross-examination at the time of
Yes.
proceeding.
Yes.
That is the best way. If you feel that they are again going to contradict it, then don't go for cross filing, etc. Straightway in the execution proceedings, you can ask for the personal cross-examination. There, whatever statement is given, that will find out. Friends, what I was pointing out was subsection C, subject to provisions of section 41 and 43A, the tax charge in respect of such supply has been actually paid to the government, either in cash or through utilization of input tax credit admissible in respect of the said supply. So who has paid? The tax charge in respect of, charge is done by supply, and that tax has to have been got paid. So suppose my supplier has not paid, but my earlier supplier, his earlier supplier has paid. I don't think that will be eligible to you ITC. The language from that it appears like that. Of course, we can always try that though my immediate vendor has declared himself hawala or is not paid, but on earlier occasion, original stand, they have already got paid. The language is same goods pe nahi hai, tax paid on the same good, then it would have been easy for us. Here there's a charge is only by supplier, and that should have been got paid. So they want that the supplier, your immediate supplier should pay. You cannot go beyond that. And that of course works positively also. There is one case of Delhi where the tax credit was allowed or ITC was got to be disallowed on the basis that your vendor is okay, but his earlier vendors are bogus and he has purchased from the bogus dealers. That is why they denied to give him refund. He was exporter. Then the High Court said that Baba, there is only what we know from the law is that you can check up with the immediate supplier. You cannot go beyond that. And that is why based on further vendors, whether right or wrong, you cannot disallow setup of the buyer. So this is how sometimes it is useful to us. Because we can always say that I don't know whether what my vendor has done, but so far as my vendor is available on the record, he has filed the return, and he still today is a genuine dealer. Because IT should be allowed to me. Yes.
Paid the tax to the government, then only he has discharged that to ITC, which is not because of this view. Earlier vendors are not paid. Coming to the clutches of this particular business.
No, that first of all, they have to decide there, no, whether it's admissible. Allowed nahi hai, sir. I could not. It is not allowed to them to go beyond my immediate vendor. No, but see, whether admissible or not in his case has to be decided in his case. No, how they can come to me? He can go. No, he can go. He can catch hold of my vendor. Department can catch hold of my vendor that you are wrongly taken credit from your vendors who are not paid. So they let them disallow to him. But when allowing to me, they cannot go into that aspect. वो क्या बोलते हैं? So they will decide, but that they have to block his account, etc. So that is what. So unless all that legal proceeding done simply because he has not paid or his vendor appears to be suspicious, etc. Then what my submission is that unless my vendor some action is taken on my vendor regarding his disallowance, they cannot come to me. Either by a portal they can stop his ITC and say that now it is not eligible. That's it. So now today also what is happening? All hawala dealers are free. उनका कोई VAT में भी नहीं आज भी नहीं है. But the genuine purchasers are being affected. So at least they should be taken to task first. Anyhow, that 38 section, let us see friends, if you are directly on us. Now coming to furnishing of return under section 39, that claimant dealer has to get this recipient has to file return. Then payment to supplier within 180 days. Now this is again a big issue. I think in all GST audit they are harping upon this, but they say that this is manageable. हमको 180 days के पहले हमको दे दो तो we will not find out this. Anyhow, this is again a issue, and Mike दो भाई.
कि आप रिवर्स करो और वापस पे करो, मतलब सॉरी पे करो मतलब रिवर्स और वापस क्लेम करो.
Reclaim is allowed subject to payment is made. No?
क्या होता है जरा ये एक एग्जांपल लेता हूँ. Suppose my 180 days I got over yesterday or maybe last month. तो वो क्या बोलते हैं कि आज उसका रिवर्सल करो, मतलब आज पेमेंट करो और उसको आज क्लेम करो और एक महीने का इंटरेस्ट दो. तो मैं बोलता हूँ कि क्यों मैं रिवर्स करके वापस क्लेम करूँ? I'll pay interest.
Only interest.
What is the problem? Why this technically? आपका क्या व्यू है? और वो क्लेम करने का बात के हिसाब से वो क्लेम करने का टाइम निकल गया होगा.
नहीं उसका टाइम लिमिट नहीं है.
और आज मुझे बोल रहे हैं कि आज रिवर्स करो जिसका मैंने कल पे किया है, मतलब पेमेंट ही हो गया है वेंडर को, लेकिन वो अभी 5 साल का कर रहे हो आगे. They are coming for 5 years and now they are digging out all the past records और उसमें जो भी 180 डेज के बाद के पेमेंट है तो आज के दिन में मैंने पेमेंट कर रखे हैं वेंडर्स को, लेकिन आज मुझे बोल रहे हैं कि ये आपने लेट पेमेंट किया है तो इसका रिवर्स करो और वापस रिक्लेम करो. Why I should reverse and reclaim? At the most I will make payment of interest.
तो कोर्ट में जाएगा कोर्ट वही बोलेंगे. But Dinesh, when you go to High Court, they will always say go by law. What law says you have to pay as an output tax liability, I think now, and then you take whatever is available. So what they are practically doing and agreeing for interest, well and good. Otherwise, legally you cannot say that you only charge me interest and forget about payment, etc. Pay the amount and then claim it back, and then interest whatever is there may come. नहीं है, उसको टाइम लिमिट नहीं है. प्रॉब्लम क्या आ रहा है, लेकिन क्लेम तो कर सकते हैं मैचिंग का. है यू मीन टू नाउ अभी 2B में नहीं है तो वी कैन नॉट इंक्रीज. अच्छा तो क्लॉज अच्छा 3B. अच्छा. So now, as per more further information from our friends, when you are reversing it, you have to pay through 3B. यानी ये महीने में हो गया तो जब इसका रिटर्न फाइल करते हैं वो टाइम पे ऐड करो और बाद में you can claim it in next month or immediately you can take. Immediately you can take, but you have to pay. Payment is required. So this is now some people are doing 180 days में नहीं होता है, on 188 days or something like they convert it into long term loan and say payment is done, अभी ये loan है हमारे, तो ऐसा एक पेपर साइन करके रखने का जब भी लगेगा तभी वो लोन कर देंगे. Of course it should be reflected according to the balance sheet also that it has been converted to loan. Yes, उनकी तरह माइक दो.
There's an issue regarding 2017. Suppose we say that the outstanding is more than the prior to 2017 outstanding also that after GST Law. So can we say that the prior period payment is still due and I paid for GST?
You can always say payment out which bill you have to make payment, that is your choice. You can always say that and take consent of your supplier also that yes, we have kept that as a pending with him and we have collected this month. It is available, you can manage it, no problem. Anyhow, this is what the conditions are and we have to learn out of that. आज के पेपर में ही आया है कि now they are raising demands for giving credit to the buyers. बाइक अभी 180 डेज के ऊपर जाते हैं तो दे आर डिसअलाउइंग. तो हेडिंग क्या है न्यूज़पेपर में कि उधारी पे माल बेचा इसलिए अब इनको उधारी पे माल परचेस करे इसको आईटीसी नहीं मिलता.
With consent that we are not paying, then will that section attract that?
So you will say it is not a willful failure, but because of
It is not. My credit is more than 6%.
नहीं फिर तो क्रेडिट. अच्छा, ओरिजिनल क्रेडिट. Now this is very
Failure on my part.
hey, we can always say अभी now there are number of payments where they are coming only after that the time of contract में ऐसे होता है ना, रिटेंशन रहता है which comes only after a certain period. And अभी उन्होंने क्या I think full payment should do then only you can take. पहले proportionally allowed था. Now they want that full amount should have been paid then only you can take. पार्टली लिया तो पार्टली नहीं मिलेगा. लैंग्वेज अभी yeah. Okay. उसका तो क्लेरिफिकेशन कौन सा आया? बाय सर्कुलर है. दीपक भाई देन यू कैन टेक दैट. पर लॉन्ग में तो ऐसा लिखा है फुल पेमेंट. हाँ अपने बार पढ़ते हैं अभी सब लोग बैठे हैं तो कुछ और आइडिया मिलेगा. Provided also that the recipient shall be entitled to avail of the provided further that where a recipient fails to pay to the supplier of goods or service or both, other than the supplier on which the tax is payable on reverse charge basis, the amount towards the value of supply along with tax payable thereon within a period of 180 days from the date of issue of invoice by the supplier, an amount equal to the input tax credit availed by the recipient shall be added to his output tax liability. So here they want full payment, value of the goods and tax. No, they are saying no, that supply which is payable on reverse charge basis, the amount towards the value of supply along with tax payable thereon within a period of 180 days from the date of issue of invoice by the supplier, an amount equal to the input tax credit availed by the recipient shall be added. So whatever you avail should be in reverse. The amount toward the value of supply. What is value of supply? They don't want. Previously, you should compare the language with previous one. We feel that they have changed this. Of course, another study circle रख देना तो. जरा थोड़ा नेक्स्ट स्टडी सर्कल रखो. एक और स्टडी करना पड़ेगा सेक्शन वाइज. सब सेक्शन वाइज रखना पड़ेगा. Anyhow, but there is difference in language after amendments. That is why it is feeling that proportionately they may not agree. Anyhow, you can definitely try that because these are all arguable points. Then, if tax component capitalized and depreciation under income tax at claim, no ITC on to such an extent. So that is okay. Then for previous years, no ITC after 30th day of November. Previously it was 30th September of next financial year. We are on 16/4 today. So we will discuss that in detail one by one. Then the conditions in GST far stringent as compared to VAT. VAT now after going through GST 5-6 years, we feel that it was much easier. When VAT came, we said that GST was easier. So these are days are changing. And now really, but these are very stringent to the trader community. And compliance of time limits, etc. Invoice matching and all these things going to be a very particular job for businessmen as well as the practitioners. Then friends, mismatch. We are already used to the mismatch concept now. They based on the J1, J2 under VAT. And slowly, in the initial years, 8, 9, 9, 10, 10, 11, etc., we have problems, our vendors and we not matching, etc. But slowly, we have got good control over it and it was useful. And that was sufficient time to file your audit report. At that time, you have to match. So people had to lot of time to adjust your accounts and give all these things. But now, it is going to be invoice wise. So this is a very, one way it is good and one way it is going to have some issues also for genuine buyers. Now suppose if the vendor deliberately omits to show sale in its J1, this is now we are encountering certain issues in the VAT era. And the buyer will be a sufferer in spite of tax bill. They are simply because they are dispute. Sometimes they are withholding showing in the J1. And then we have to go back to them and then they are having their own terms that you first adjust this and that. Anyhow, this is what, because department is not keen on pursuing the vendors. They simply say that it is a mismatch. Aapka set of disallowed ho jayega. We don't know whether vendor will pay or not pay and etc. etc. So actually the department should pursue them. But now in Mahalakshmi also, as well as now the recent judgment, Patna High Court, etc., they are saying that we don't know about vendor whether he will do. We will disallow you because you are not complied with the condition. So this is how the difficulties arising to the genuine buyers. But in our Maharashtra, there is one circular under, as far as VAT credit is concerned, 21A of 2018 dated 4/8/2018. It is internal circular, but by that they have said that those who have complaints against the sellers, they should file one complaint with the additional commissioner mentioned in that, and he will pursue through his assessing authority to the seller's authority, seller's assessing authority. They will pursue the seller. What has happened? Why he has not paid, or whether he has shown not? Why not show? Sometimes it gives good result because if the selling assessing authority is much more competent, he will enforce upon the vendor to file J1 or pay the tax, pay the return, etc., etc. Of course, all these things are how far you can pursue based on that. And again, you can use RTI. What happened to my complaint and this and that. So after 2, 3, 4 months, we may get some result. But it is better. But now under GST, I think the days are going to be difficult from that angle. Then facilitable confirmations was also given under VAT period. Physical up to 12/13 and online from 13/14. And because of this facility, even if there is a mismatch, you are able to cope up with the same, with all these issues. Now, under GST period up to 30th September 2022, there was old provisions. Some of them are changed from 110/2022. Now, as far as I know, because I am not well accustomed with all these things, but from reading, I know that no invoice-wise cross-matching on system portal was there up to 30th September. It was only GSTR 1 we looked into, but that was not a hurdle to stop your ITC, because you can take it as per your records, subject to 5%, 20% initially. Further, initially they have allowed access to be taken. And the procedure for mismatch was spelled out in sections 41, 42, 43, and 43A. At least relevant section I have noted. And what are those sections? Of course, because now we will be facing some assessments or adjudications till 30th September 2022. Till that time, that old will apply. So let us see what are those sections. Section 42, that was the duty was upon the department to match it. You can take it as per your invoices. Now it is department who is to find out that this is not matching or this is your taken access, etc. And we are receiving notices from 17, 18 till 2021, etc. Based on that, there is an access claim by you compared to matching in 3B and their 2A, etc. GSTR 2A. So they used to give notices, and we have to reply. And at that time, we have to see what will happen, whether matching is possible or not. I remember one case where demand was raised based on that mismatch, and then that order was also passed. Time for appeal also has gone out, but then we find out that there was a portal mistake itself. The supplier have filed their GSTR 1, but not reflected. When we pointed to assessing authority, he himself rectified it bona fidely. So this is where certain good officers are there, that in spite of time limit, under clerical mistake, he rectified it. So if the officers are good, they will understand difficulties. Otherwise, you have to run behind that. Mismatch with supplier or with IGST paid in customs. Now that is also issue. Up till today, there are a number of litigations based on IGST not reflected on the system, and that is why they are disallowing it. And when we go with bill of entries, after order is passed, then again the stark reply, it was not there, you have not come in hearing, you will not now do anything, etc. So where the officers are not able to take bold step, they will not get the justice, and you have to file appeals. And if appeals time is also gone, then there will be much more running for you. So friends, these all cases are there in adjudication, and number of cases involved in litigation are out of this mismatch only. Then there is section 42. This is a very important section, 42(3). What it says: duty on department to convey mismatch, that is access claim as compared to supplier or not shown by supplier to both supplier and recipient. This 21A 2018 circular which I referred, it is already embodied in the section 42(3), which was operative up to September 2022. And it was duty upon the department to give notices to both claimant, that is a recipient, and the supplier. And if they don't take it, then we will say that he has done not correct as per law. And duplication of claim also can be conveyed to recipient. If suppose I have taken duplicate, that they will convey to only recipient. Now, if supplier do not rectify the mismatch, the liability on recipient as output tax liability, as per that section 42 provisions, that suppose they have conveyed the mismatch and the supplier does not take any action to correct it, then it will consider as an output tax liability, and they will raise the demand in DRC 07, etc. Now, but giving notice to supplier is going to give a good result, because he will be alerted that some action will be taken upon me also. And really, if there is a bona fide mistakes, he will definitely come forward and the matching will be done. But wherever you are having problems with the vendors, you yourself know that my vendor is not genuine one or correct one, or there is some problem on his part, then you take technical objection, because normally I have seen in adjudication, they are not going to the supplier. They are only saying to you that this is your mismatch, you prove it now. But if you point out section 42(3), it becomes a duty upon that. And if they don't follow it, in further litigation, it will be helpful to you that he has done it without complying with the law. And these technical mistakes, at least in the High Court, I have seen they are very punctually based on that. They feel that there is an injustice to the party. Either they will remand or they will say that this allowance is wrong. Then also there is a provision that suppose supplier does it afterwards, then also liability can be reduced and interest suppose they have paid, it can be given back to you. That was section 42. Then 43(6) also provided joint and several liability in case of detailed GST on furnished but return not filed. Suppose my name is shown in GSTR 1, but the supplier does not file 3B. Then it becomes a joint and several liability for payment of tax of that particular. Now these all things you have to provide to the officer that okay, he has shown in GST 1. Now according to you have not filed GST 3B. It is your duty to go to him also. Let them the technical fault. They say that no, we don't know what your supplier will charge to you. DRC 07 issued. But this technical things, if you have raised at the down level, it will help you in the litigation. When you go to the first appellate authority, probably there also will not get justice. But at least tribunal level, we don't know what GST tribunal comes and how it works. But we feel that there it will be considered because it is duty upon them. And if they have not done that, that means there is a breach of law and principle of justice are not followed. Then friends, these are all provisions are there, but whether they follow or not, we know very well. But it is our duty to write when you are giving submission that this is how you are supposed to do. And in one of the cases, we are doing like that. It is almost 6-7 months that officer is not able to pass the order because he is saying that I have conveyed to suppliers officer, let report come from him, then only I can pass your order. Otherwise, it will again defect your order. So wherever possible, you can use these provisions. Now, that is ultimately in your submissions, whenever you are making about mismatch issues, you should take these sections, write out to them, let them do it or not do it. Then friends, fortunately, following Maharashtra, the GST Council came out with this confirmation system and they have issued 2 circulars. One is 183 dated so and so. And it was for the period 17, 18, 18, 19. They have said that you bring the confirmations as we bring it in case of J1, J2. And according to me, up to 5 lakhs direct suppliers confirmation was okay. And if it is mismatch more than 5 lakhs, then you have to bring it in a CS certificate form. But this is a good thing, at least at present, because people are getting difficulties in mismatch and they can be resolved by this confirmation system. And this circular is again extended for the period up to 31/12/2021 and not up to 22 also, because according to them from 1/1/2022, that 2B system has come fully in operation. So they say that now you go according to matching as per that GSTR 2B, and this facility is only applicable up to 31/12/2021. If anybody has any other information in this, kindly tell us also, because practically, yeah. No, they say that consumption should be full amount, but that rule of 5%, 10% was there, no? So that should be applied by while taking the 30%. Yes, because that was not fitting. Suppose no, they say that suppose he has not shown, supplier has not shown the invoice, then it was fully disallowable. You bring confirmation, it is allowable now, but subject to that 5%, 20% conditions. Yeah. That difference will still remain disallowable. Yes.
In between the years, then 5 or 20, 10, 5 years.
Monthly.
Not quarterly or annual. That
Monthly.
means essentially whatever credit that was allowed to you as a rule will only be allowed as.
That's right. By confirmation. Nothing more than that. They want to say that suppose originally you had an invoice, you would have got this much set off. See, that same will you get by confirmation. Appeal में क्या करेंगे आप? While going in appeal.
Based on my invoices uploaded on the test. And the rules that is allowing me the percentage of 120%. They have no business to disclose the set of to that extent. And rule 36 allows me the set of 120% for October to the January. It was there. And then in the COVID,
They have given some concession. Cumulative.
For that, cumulative. And then it has to be every month.
Monthly.
When the rule 36 allows me the set of 120%, then according to the section 73 will not apply. Or I have not claimed the ITC wrongly. See, ultimately for mismatch, they have to go to section 76. Now 73 says wrong ITC covered or erroneous refund. That is the true ground of this. So when I have covered the ITC for rule 36(4).
No, difference will arise if suppose you have taken 130. You are allowed up to 120. That problem will come.
In that case, section 42 is still there. The rule 36(4) cannot override section 42. So 42 says that mismatch mechanism will come only after R2 is filed. You look at that. Section 38 is deleted now.
Okay.
Section 38 provides the filing of the R2 that was deleted now in the January 23.
Barabar.
They are not deleted. So as per section 32, I was to file the R2 as and when to be notified. Rule 69 and 70 say the matching concept as per section 42 would start when R2 when I file R2. When I file R2, then only matching is the file. R2 तो आज तक नहीं है, वो आने वाला नहीं है. So how can they start the matching concept?
So there is a.
For that, and you can't say that I have claimed the ITC wrongly as per section 30.
That is good defense because there is no system available immediately.
But the government has said that till then you are entitled to actually ITC as per your books of.
But then in this circular 193, they have given example that you are entitled to 5% more. You have taken extra, so that will still remain disallowable. That is what Deepak is. So their interpretation is still there. It should be strictly as per the given percentage. So it is a matter which can be argued before tribunal. That has already come. Yeah. That's right. Okay. Anyhow, but these are going to be very ticklish issues coming to. Now, let us move fast because some judgments you have to see. Now, not extended from 122 as GST to be introduced on the portal from 122. Now, judgments about mismatch because I am supposed to speak upon judgments. So what are the judgments? First judgment, DY Bithal Enterprises of the Madras High Court. There, the issue was about GST credit when the supplier has not come forward or they have not taken. Now, here exactly, I could have followed the section 42(3). What it says? GST, recovery of input as credit of non-payment of GST by seller. Validity of recovery from petitioner. Buyer in the absence of similar recovery action against the seller. Challenge to automatic reversal of input as credit from the buyer on the payment of non-payment of tax by the seller. Held the respondent does not appear to have taken any recovery action against the seller on the present transactions. When the seller has collected tax from the purchasing dealers, the obligation on the part of the seller to remit the tax in question must have been reviewed. Must have been viewed seriously, and the strict action ought to have been initiated against the seller. In the inquiry in question, the seller ought to have been examined, and this is all the more necessary because the respondent has alleged that the petitioners have not even received the goods and had availed input as credit in the strength of generated invoices. The impugned order suffers from fundamental clause of non-examination of seller in the inquiry and non-initiation of recovery against action against the seller in the first place. The impugned orders are quashed and the matter is remitted back to the file of the respondent. The writ petitions are allowed. So this was one of the judgments which said that seller should be first examined what has happened, etc., etc. Without that, you cannot disallow the ITC. Now, this was a good judgment. As and when mismatch comes, first of all, you should put the judgment and say that it is your duty to do all these things, otherwise it is bad in law. I know that they are not going to give any relief on this, but just put it on the record. In future, it will be useful to you whenever you are in up to High Court, etc. Then similar to a stand taken by Calcutta High Court in more than 1, 2, 3 judgments. I have given only 1 year. That is a recent one. Suncraft Energy. Same, they say that you have to pursue the seller, give notice to them, and then only you can come to buyer. Now, what is contrary review that is important? That is in case of Asta Enterprises and State of Bihar, Patna High Court. Now, they have totally turned the position what were taken by BF, BI, Bithal and other judgments. In Asta, the Patna High Court has said lot many arguments were made, but they are not, they are saying that. I will just go through that judgment. Important paragraph. See, one is that learned counsel for the petitioner had specifically argued that the said decision of the Honorable Supreme Court can be distinguished, especially looking to Section 70 of the caveat, and also the petitioner herein having produced not only the invoices but also the account details and the documents evidencing transportation of goods. However, we have to notice that this does not absolve the SSC from the rigor provided under subclause C of Section 16(2), that is non-payment of tax by seller, of the BGST Act, which require the credit of tax collected from the purchase dealer, either in cash or through utilization of admissible input tax credit, being available in the context of the supplier having actually paid into the paid to the government. This is effect. This in effect is a burden of proof cast on the purchasing dealer who claims input tax credit, which is a right created under statute, sustained only under the specific terms and terms of the statute. Now, this Patna High Court says that it is a duty on the buyer to prove that my seller has paid the tax. So, whole card is reversed now. BI, Bithal, Calcutta High Court, etc. are sidelined. They say that if at all your supplier pays subsequently, they will refund you, but you are bound to pay first because they have found out that they have not paid. Now, here that section 42, etc. are not cited, and that is how difficulties will arise. So now, friends, department has got a tool in their hands to say that we are not supposed to do everything. If we get it from the supplier, we'll refund you, but today you immediately pay. Even Mahalakshmi also is on the similar line. They are also undertaking as given by the government. They have also stated that we'll pursue the seller, and if you get it, we'll refund it back without even refund application. नहीं, हवाला का जब वो भरता है तो हवाला नहीं होएगा, समझ के चलो.
Payment confirmation from that dealer. How you declare Hawala. But even then, this undertaking is for other dealers, not Hawala. Same can be taken for NTPC because NTPC now they are saying they are not going to assess. Here also, the same that they are not going to assess the penalty.
But we can say, Hawala to aap log bol rahe, so far as we are concerned, right? And we have got one tribunal judgment which has said even if tax is paid by Hawala, still the credit should be given. One tribunal judgment is there. Then, what other objective or what para I wanted to say? The government definitely could use its machinery to recover the amounts from the selling dealer, and if such amounts are recovered at a later point of time, the purchasing dealer who paid the tax to its supplier could possibly seek for refund. However, as long as the tax paid by the purchaser to the supplier is not paid up to the government by the supplier, the purchaser cannot raise a claim of input tax credit under the statute. ऐसा पूरा burden डाल दिया. Possibly they will refund, you try, etc., etc. But so far as you are concerned, so I think this is contrary to the commitment of the government, and probably because of this they will leave it of pursuing the sellers, suppliers. वो उनका पटना कोर्ट ने वो भी बोला है कि तुम्हारा इंटरनल मामला है, you can go to courts and fight out with the why are not paid, what he has to do, etc. But we government cannot be compelled to give ITC. So the things are. आप क्रिमिनल भी ले सकते हैं, ब्रीच ऑफ ट्रस्ट करके, भाई यू कलेक्टेड फ्रॉम मी ऑन गवर्नमेंट्स बेसिस बट यू आर नॉट पेड, एंड यू कैन गो बाय सिविल सूट आल्सो, समरी सूट, सिविल सूट जो भी होते हैं. एफिडेविट से कुछ काम नहीं होएगा. वो तो इनवॉइसेस में सब में लिखा होता ही है ना, वो से तो but how to protect Janak Vaipur?
That was a totally and separate case. So when there was a study, he is not paid. That was the High Court yesterday, he is not paid the tax. Then it is no.
But no, but they have said duties cast upon the buyer to prove that he has paid the tax.
In the
नहीं वो सब ऐसे ही होते हैं. जब who is not paying the tax, supplier तो ऐसे वही नहीं भरने वाले. But now we are finding out what should be our defense. वो सब इशू आए नहीं इसके अंदर, हाईकोर्ट के अंदर वो सब आए नहीं है. I don't know is raised or not raised. वो तो हाईकोर्ट ये भी बोला कि unfortunately they have come before high court, they should have gone to appeal. खुद बोलते हैं, because these are not the issue to be taken to high court. The high court will only give relief if it is within the constitutional provisions or any direct breach of the law. Interpretation का काम, factual points का काम उनका नहीं है. नहीं डिसमिस कर दिया. पूरा डिसमिस कर दिया. अभी अपील कर सकता है कि नहीं, वी डोंट नो. अभी करेंगे तो भी क्या देंगे? हाईकोर्ट जब निगेटिव बोला है तो हु इज गोइंग टू गिव हिम? नोबडी विल. अगर वो बोलते थे कि भाई स्टिल यू हैव गॉट अ चांस टू फाइल अपील इफ यू वांट टू गिव फैक्चुअल पोजीशन, no, nothing, dismissed. And observing all these things, so my submission is Janak may be right in saying that you can still prove, but what to prove now? वो आपके पास कब आते हैं? Either he has not filed return, he has not shown in his GSTR1 or something like that. Where how you are going to prove that he has paid the tax? So in each and every case that problem will arise.
We are getting is for the mismatch. But if there is a finding that we have not paid the tax or the RC cannot know because that is also that they cannot issue the RC from the recovery.
Right, that is different. What we are saying is that when they say there's a mismatch, so what is the meaning of that? He has neither not shown sale to me, or he was shown but he has not filed return, not paid the tax.
They have got the parameter, and there is a notice for not filing the return not paid. There is a difference in the notice. Mismatch is not an accused or not filed. Our return is filed, tax is paid, what is not reported in my house. Then there is a one more parameter, RC cancel. RC cancel may be a frustrator, maybe.
That is okay. No, but now having observation of the Patna High Court that it is a duty upon the buyer to prove. Up till now, अपन वो पकड़ के चलते थे. Department should prove. He should be assessed. He should be applied all machinery for recovery. वो थोड़ा difficult हो जाएगा. Now, friends, we'll go to further present situation of taxpayers. Have to be vigilant. Section 41, 42, 43, etc. deleted from 1/2022. Then new GSTR to be the master guide, उसके हिसाब से चलो. One way good to safeguard the recipient, timely feedback for corrective action. वो 11 तारीख को मालूम पड़ जाता है मेरा क्या सिचुएशन. 13, 14, हाँ वो 11 पकड़ के चलते हैं. Because that is the ultimate. उसके बाद कभी भी मालूम पड़ सकता है. However, taxpayer facing liquidity crunch due to various circumstances not within control of taxpayer, the situation will be worse. Such taxpayer will be thrown out of business because एक बार एक महीने में नहीं गया तो गया काम से, उसका कोई लेगा नहीं माल आगे जाके. So this is going to difficult situation for small dealers. Government should have middle way, installment facility, and some liberal approach. At least sellers should be allowed to file returns, give some installment facility for 5, 6 months, 12 months like that. So they will catch up. अभी किसी का समझो कोई all of a sudden कुछ liquidity problem आ गया because of any reason, he should not be thrown out of this. Then education of defaulters and application of all recovery procedure must before the disallowance. This will bring accountability to the department. Otherwise, it is one-sided game. अभी तो सिर्फ वो mismatch बोलते हैं अभी नहीं भरा आप भर दो. They should be even at least they should follow as Janak says. It should be assessed, should be done. Now coming to last section 16(4). सेक्शन 16(4) का रीडिंग क्या बोलता है? Eligibility and conditions for taking input tax credit. A registered person shall not be entitled to take input tax credit in respect of any invoice or debit note for supply of goods or services or both after the 30th day of November following the end of financial year to which such invoice or debit note pertains or furnishing of the relevant annual return whichever is earlier. So shortly we say that you have to show your ITC for previous year up to the returns filed up to 30th November. उसके बाद जाएगा तो नहीं मिलेगा. तो मेरे हिसाब से there are two interpretations. Now Patna High Court, Andhra Pradesh High Court has given drastic judgment. But what we should interpret this to show ITC of previous year in returns to be filed till 30th November. But filing returns they belatedly should not affect the claim. मेरा ये कहना है. You have to show the ITC in your returns which are to be filed up to November, that is October, for example, practically. And filing that October return even in December should not affect your claim because what they want to show ITC of previous year in returns to be filed till 30th November. I will dissect that section and again show. Other view is that showing in return due up to 30th November and filing return till 30th November necessary. That is another view. That the return filing should also be before 30th November. Now what happened further? अपन जो अगर dissect करके section पढ़ते हैं, to dissect the dissected section 16(4) can be read as under: a registered person shall not be entitled to take input tax credit in respect of any invoice or debit note for supply of goods or service or both after the 30th day of November following the end of financial year to which such invoice or debit note pertains or furnish or annual return. इधर किधर लिखा है कि return of 30th return should also be filed up to 30th November. So we can take a view that yes, if I take in December return, it is totally out. But if I take up to October return, though it is filed in December or January, according to me, it should be permissible. At least there is scope to say that yes, if there is a doubt, it can be resolved in favor of the dealer. That is what normal principles of. The third view is there. Okay. By Mike though.
What use is take ITC, entitled to take ITC. It is entitled to take ITC. It doesn't say is entitled to claim ITC. Claiming is by way of return, and taking is by way of entering into the books of accounts. I have entered in my books of accounts before 30th of November. This can be
Yes,
third argument.
तो ये रिटर्न इसका अपना कहना क्या है कि it should be related or it should be entered in the books of accounts up to 30th November.
Yes, 30th November.
So that is another good. It can go up to any time then.
It is not claiming, no.
Yes. So claim I can do in 25 also, 2024, 2025. But anyhow, this is what some interpretation we can do. The section requires claim of ITC of previous year in return due till 30th November. No condition of filings or return up till 30th November. So view can be taken that claim should be shown accounted in return due to be filed up to 30th November and return can be filed even after 30th November. This should be justifiable interpretation. But अभी क्या हुआ? AP High Court judgment case of this Thirumalakanda plywoods, the recent judgment, July. Return of March 2020 was filed on 27/11/2020. ITC claim in the return disallowed with levy of interest and 100% penalty. 4 लाख का ITC डिसअलाउ हुआ मार्च महीने का, उसके ऊपर इंटरेस्ट आया और उसके ऊपर 4 लाख का पेनल्टी लगा दिया. आर्ग्यूमेंट्स सब कॉन्स्टिट्यूशनल आर्ग्यूमेंट कर दिए, डिनाइंग ITC अनकॉन्स्टिट्यूशनल, टाइम लिमिट गेट वेव्ड बाय लेट फीस, सेक्शन 62 ओवरराइड, सेक्शन 16(4). वो 3-4 मेजर आर्ग्यूमेंट्स मैंने जब नोट किए हैं. They say that it is unconstitutional because it amounts to restriction on my business, double taxation, etc. Then उनका कहना था we have filed this March return with delayed fees or late fees, so it becomes time in time, and otherwise it also section 16(2) says that notwithstanding content. So they say that even 16(4) is to be overridden by section 16(2), and as per section 16(2) I have filed return, so I should be getting it. And this all constitutional, they have not given this view which I have conveyed, that return filing is not important up to that date, or as per Dinesh, that I am entitled to claim and in the return wherever I find. So these arguments are not fully made. Then Honorable High Court says, rejecting the arguments of the petitioner, held that return to be filed till 20th October 2020. In this judgment, second view is upheld and writ petition dismissed in toto. No argument the first view. So friends, according to me, don't jump to High Court on interpretation issues. This is better to go by ladder. So more and more light will be coming up into that. High Court is the ultimate. उसके पास Supreme Court जाने वाले तो High Court में जाने का कर दिया. Otherwise, High Court will not. And they are very much keen upon legal interpretation. अगर आप pinpointedly बताएंगे, this is the breach of law, then only they will accept your argument. Otherwise, you can't say that they will take a lenient view or मैं छोटा हूँ, मैं बड़ा हूँ, कुछ सुनते नहीं है. Therefore, distinguishing above judgment is still possible, safeguarding interest of both sides. Under GST, large number of traders affected as compared to excise law. अभी सब पूरा excise में से आया हुआ है, ऐसा बोलते हैं लोग. Because we are not practiced in excise. But अभी इतने बहुत छोटे-छोटे traders होते हैं, compliance है. So they should not on technical basis disallow this. Liberal position required. When government has got the tax, the ITC is required to be granted. Normally, natural justice, justifiable reason, and financial burden on small dealers concerned, they should give ITC, though it may be at some reduced percentage. Baba, abhi aapne late kiya return, instead of 100%, you get 95%. We can understand. But denying totally and raising full liability will definitely affect them very heavily. Some may be thrown out of the business. That disallowance on technically is also not justified, because return filing is nothing but technicality. Example of Trans 1. Trans 1 का भी ऐसा ही हुआ था. You have missed the deadline, and then after 5 years, Supreme Court opened the portal and all that thing. According to me, this is the same case. They have taken the same stand. That Baba, आपको मिला तो है ना tax. They are eligible to credit or not. Otherwise, yes. Then they say don't go for technicalities. So here also same principle is required to be applied. But of course, this will take time now. Other high courts may take some different view, or Supreme Court or the government. After 5 years facility, taxpayers to continue their cases. According to me, if you are so much worried, pay the full tax and stop the interest meter. But you can litigate this issue. Something is going to come in positive according to my feeling. Then under protest भर दो. आने के बाद भर दो, उसमें कोई प्रॉब्लम नहीं है. आपका ऑर्डर आने के बाद आपने भरा है, तो you can always claim it back. There may be different views from other high courts, Supreme Court in future. The government is also required to change policy when the intention not to collect double tax. Then trade bodies should do more to create pressure on the government. Now, another argument which was made in AP High Court judgment was late fees bring the returns in time. That is one of the possible argument, that when you accepted my return with late fees, it means that you are condoning my delay and it becomes time within time. But that is rejected. High Court said that it is only for punishing for late filing of return and not bringing your return in time. Then may have some percentage reduction in IT, that is our suggestion, but this should not totally deny it. Late filing of returns by supplier should not be reasoned, because they are previously, now I think they have stopped. that my supplier also filed late, they are disallowing. That is at all not covered by section 64. So that was the wrong interpretation. But these litigations are still there. Then, friendly, let trade adopt to new system. Of course, now we cannot be lethargic. We have to be very compliant in filing returns and timely compliance, etc. But having this, that there may be a number of reasons why you could not file up to 30th November. Suppose there is a death in the family, your return becomes delayed for 1 day also. Or all of a sudden some financial setback is there, computer failure is there on the last day. So there may be a number of issues by which 30th deadline is missed for filing October return. For example, you are taken in October return. Then there should some liberal approach we can expect from the government. But looking to the High Court judgments, don't think that there may be some lenient view from the High Court. This is all the government can do it. So friends, I think I have tried to cover the topic in the allotted time. Thank you very much for making this session interactive. Thank you very much.
Audience to arrange your release. Yes.
Whether this time of 16.4 applies to IGST credit, which is paid on imports. Now see, the section 16.4 says tax invoice and debit note. While section 16.2 says you can take ITC based on your tax invoice or other documents. So when only tax invoice and debit note are mentioned in this section 16.4, so for taking it out of tax invoice or debit note, you have to comply with return by situation or condition. But if it is for IGST, then you can, I think, you can take it at any time. There is no time limit for that.
There was one question. My client received escape from the anti-evasion saying supplier has neither traceable nor paid the GST. Hence, you pay. Question: can dealer file RTI to GST Department or anti-evasion department or supplier bank to know what documents are available with them? When dealer purchase second one, when dealer purchase goods, GST number was in force. Even after the date of purchase, supplier filed GST number and three. Number three, in some cases, department cancel the GST number from the date of original registration of the supplier. Dealer has taken the legal way, kindly advice.
Now, my client received SCN from anti-evasion tax saying supplier has neither supplier is neither taxable nor paid GST, hence you pay. Question: can dealer file RTI to GST department or anti-evasion department or supplier bank to know that what documents are available with them? That RTI can be filed at any time. That is your right.
If it is an SCN, no, you should have the document only.
Yeah, that's right. That part says in the, if you're replying to SCN, that time also you can raise by give the adverse material being used against me. So that can be taken from the department and you can also file RTI. There is no problem. When dealer purchased goods, GST number was in force. After the date of the purchase, supplier filed GSTR 1 and 3B. So purchaser, no? That is what we are filing. As a purchaser, you have filed. That is what they want to say. In some cases, department cancelled the GST number from the date of registration of the supplier. Now, again, the same problem will arise. We have got old judgment in case of our BST era, Suresh Trading, that supplier's cancellation of registration retrospectively cannot affect the buyer because unless the connivance is proved. Now, here, assuming that there is no connivance is proved, then we can always say that retroactive cancellation should not affect me. But that will not solve the problem. The further problem is because that was a case of resale. So there was no question of payment. Here the again question will come whether he has paid tax or not. And if he has not paid or he has not filed the returns, then other conditions will get breached and issue will still remain there. So practically, if he is not paid the tax, basically you have to assume that litigation will not work more in his favor.
One issue. The association we should represent that in the GST law itself, we have the facility of installments.
Yes.
The installment facility is there in GST law itself to segregate the payment liability and return filing responsibility. So when I do not have fund, I have no fund, so delay may be there in returns and all. There are uncontrollable situations can be there. But majority is because of the finance.
Finance.
So I think we should suggest as an association that should segregate the returns filing. Why I am a barred to file return if I have no money. Or if I have say 5 lakh rupees and my return liability is 8 lakh, I cannot yet file the return. Though my credit may be there in electronic cash ledger or credit ledger. So I think we should really.
We have already represented. On several times we have represented this from the time when GST came, where we have represented.
In fact, because of 16.4 and all the developments like this, this will.
Is required. Facility should be given. Otherwise, the small traders will be thrown out of the business. That is going to be difficult.
To not even this liquidity due to some technical glitch, Maruti Suzuki was not able to furnish GSTPAM in time before 11. They had the data, they had everything ready. But I don't know monthly turnover of Maruti, but there must have been thousands or hundreds of crores at
When
least.
the consultant is not there, the compliance is from the consultant's office.
Office.
The staff left. Holiday was there, Sunday was there.
Sunday was
Who looks after the due Sunday or even some holiday?
The team.
That was very bad, it is not there here.
Ah.
So those since the model law, the representations have gone and it is continuing. Let us.
But now people have suffered and for crores of rupees, so they will now really understand the issue and they will then try to listen or solve the issue.
You are right. But
Then the trade
देखो,
goes, so if the trade goes maybe, but otherwise they will have.
Of course, we have limitations.
अभी गवर्नमेंट को कैसे है आपने गुजरात में કહેવાય ને કે વાઘ જો લોહી ચાકી જાય ને પછી એ છોડે ને કોઈ એટલે હવે એને ખબર પડી ગવર્નમેન્ટ ને દબા કે રખો ઓટોમેટિક પીપલ વિલ પે તો અભી वो अच्छा normally they are not going to give any liberal
आ गया ना voice file
नहीं फाइल
ये ITC तो तुमको 1.5 साल में मिलता है तो ये GST 1 भी भर नहीं सकते क्या the law is being made so tight.
change. So the problem is that they are not giving some liberal.
It's not a big sum. So slowly they'll make after 3 months 50 and then another 3 months 10.
Even that it was generated registered tax person. Generated MD number was so annoyed. OTP just get the e-invoice. That is coming back to first December.
तो अभी आप सो मत सिर्फ धंधा करो जगते रहो
दिवाली के नाम से धंधा करना benefit है
और audit निकाल दिया.
नहीं तो एडवोकेट बन जाओ
Problem is also section 80. When we talk about installment also, then we have to call for amendment to section 80 because section 80 does not talk about return due.
It's only order.
Any other difference? Any other difference?
That is what he's saying, that it should be now changed. So that one query was there, Pradeep. Shall I again speak on this? Vikram Mehta. No, Vikram Mehta's query was just answered in the starting only, in the query session. That whether we can get ITC of IGST paid on imports, etc. Even if that section 6 means whether section 16.4 will apply to that. It does not apply. So our query reply is left. My client lost his original invoice, but however, he is having copy of the invoice through transaction, though transaction reflected in GST or 2A. whether he is eligible to claim input tax credit. Section talks about purchase of invoice. He can, at the most, he should get it certified by the vendor, if at all insisted upon. But he will get. Huh?
So, and Deepak sir, I don't know if you have seen, I have seen it about.
ये तो हो गया ना?
I have seen this trend which is happening now. A lot of people are going to do that. Most key cases which are moving, the people who are affected, like CB sir was saying, the people who are affected, small traders are in trouble. But there are the medium level smart people who कुछ नहीं करते NCLT में चले और बाद में लेके दिखाओ.
NCLT जाए तो अच्छा है. Then at least we will get it. Because government has waived them. It is not that they have not paid. This government has now received and they have waived. So we can still claim.
Form भी फाइल करते हैं और ये सब. आया people बोलते हैं तुम्हारा कुछ नहीं.
So if supplier is the NCLT, I am safer.
Yes, you are entitled to get ITC. It is not a case of non-payment. It is the government who has waived the money. NCLT तो मालूम नहीं पड़ता क्या चल रहा है. अरे सब स्मॉल लोगों के पैसे चले जाते हैं. वो टाइम लिमिट कब आता है जाता है फॉर्म भरने. Nobody knows.
The taxes be paid on that transaction.
No, definitely, sir. I don't think it खाली NCLT में जाके.
No, हो जाएगा. अगर जो वेव हो गया ना वो, you can claim your ITC. He is deemed to be received by government.
So that proves that government will recover this thing.
उनको उनका 100 रुपीज का 20 रुपीज में उसको सेटल कर दिया. That is not my fault. और जीरो में किया.
They are not, who is required to file the return? Even the corporate data. There is a vacuum in the provision. So I told the government, I made it in 2020, that you allow them to file the return of ITC. So that the differential amount can be recovered or forward.
Then circular, department circular, I think it is 183 or what it is saying that in that case, the IMP is taking another number.
My one slide has remained, Janak, that regarding cancellation of RC and then subsequent restoration. There, so there the Rajasthan High Court has given a judgment that suppose you are RC is cancelled and then restored subsequently, and by that time your time limit of 16 etc. gone, still you can file your claim when you file the returns after restoration. So according to me, in that case, this 16(4) will not apply.
That before the rule 23A, the possible due date for filing of the return, when your number is cancel which is level. So as per the within 30 days you have to file the return.
In that you can claim.
So for the purpose of 16(4), the due date of the return filing is this day.
30 days.
Now the problem is that now 30th November is the due date fixed in the extra section 16(4). So now in the recent amnesty scheme, if you have applied for the revocation and it will be cancelled after 30th November, then what will happen?
No, anytime. Suppose your number.
Section 16(4) says that it is to be claimed on or before 30th November of the next year. It does not talk about due date of filing of the return. So it is a permanent date is fixed. Now that I represented to the government that is to be interpreted. So when I am not allowed to file the return, then the 16(4) proviso is to be updated subsequent to the date of revocation.
And then within 30 days from.
No. See, if my RC is revoked today, cancellation revoked today, then it will have the 30th number of the next year.
Next year.
Not of this year. That has to be interpreted because you can't say that it is impossible to perform. And the rule 23 says my due date of filing of the return is within 30 days, which happens after 30th.
30th.
then that is to be read down accordingly. And there were a lot of judgments.
Anyhow, but at least that is a good judgment by Rajasthan High Court. It will help us.
Only,
for
they have not considered the 16 for 30th number.
They are not considered, but they have said you can claim it in the returns which you file after
They
revocation.
have not considered 16 for the 30th number.
They have not considered that, but we can take that logical.
Otherwise, I will lose 6 circular is there. I mean, because you know very well that is the sufficiency of that circular about that circular. The commissioner was here and he said, and at that time we have said that you are asking for the payment of the tax in the cash. I think without filing of the return, I cannot make the payment of the tax. So I have to make the payment of the tax only for the return up to the date of cancellation.
Cancellation.
Not between the date of cancellation to revocation.
थैंक यू सर आपका सारा रिप्रेजेंटेशन हमको भी दे दो आप इंडिपेंडेंटली इंडिविजुअल रिप्रेजेंटेशन करते हो हमको आपने बोला ना 2-4 रिप्रेजेंटेशन आपने किए हमको हेल्प हो जाएगा कन्वीनर का मेल पे भेजते हो ठीक है कन्वीनर को बोलता हूँ दिखाने अच्छा एक लास्ट क्वेरी लास्ट एक ओनली फॉर द झालं का
सब लोग
अच्छा एक कॉमन क्वेरी है सबका होता है वो कि वेंडर जो है वो बिलेटेड रिटर्न फाइल करता है और मेरा क्लेम जो है वो इन टाइम है 30 नवंबर के पहले तो डिपार्टमेंट ऐसे केसेस में बोलता है कि आपका सेट ऑफ डिसअलाउ होगा
That is already covered. That is not covered.
There are 89 problems.
No, still there is
Provides
a
no
problem.
provisions only for one.
The issue which I am raising is that since he has filed late, he is not eligible for ITC.
That is what that I have taken up in short. I thought that.
What they are saying is this common offline थोड़ा कम हुआ है. But what he means to say is कि suppose आपका supplier उसने रिटर्न लेट फाइल तो दैट मींस उसका वो रिटर्न ही वैलिड थी तो आप आईटीसी नहीं ले सकते
चलिए उसका ITC एलिजिबल नहीं हो.
But what that is too far. That will be a very far-fetched interpretation.
Yeah, but he is paying
नहीं नहीं ये जो मैडम ने बताया ना कि उसको एडमिसिबल ही नहीं है तो दैट वेंडर हैज नॉट पेड टैक्स एज गुड एज ऐसा एक इंटरप्रिटेशन थर्ड डिग्री
And vendors file late, then you get the ITC. So in the Maharashtra, in the State Department, they are not issuing it.
Okay. But initially there are some disallowances have come for which
that legal or people over right they say no.
अच्छा
So there is a apparent contradiction between the state sector and the central government.
At least we can be definitely sure we'll get it because we have no control over the vendor filing return. He has paid tax or not, that is the condition. Condition is that he should have paid tax. I have filed return according to.
There is a 16-point provision. 16.8 is the provision. That creates a
provision. Anyhow, let us see. अगर कोई आंध्र प्रदेश हाईकोर्ट जैसा आ जाएगा तो बोलेगा नहीं मिलता है. We'll have to face. They are also going very casually in High Court. ये मेरे को लग रहा है कि डायरेक्ट भागते हैं कोई भी से प्रॉब्लम करके रखती है.
Now we'll conclude session. Today it's very interactive session. CB sir has explained the topic in a very detailed manner. I really appreciate CB sir to give a lot of input and important judgment. Thank you, sir. I will request Aditya for further proceeding. Please, Aditya. Sunil sir, please. There are one presentation from Expo on some useful online tools. I request Mr. Kapoor of Expo
Wait for only 5 to 6 minutes.
नक्की या, हरवू नकोस.
Passport. एक मन चालू आहे.
कर सकते हैं
यहाँ पे लॉगिन करना पड़ेगा।
हाँ कर दीजिए चालू है बिल्कुल
स्क्रीन खाली करो, उनको चालू कर देना ना। चल ये लग जाएगा तो ज्यादा अच्छा रहेगा बेटे, कि मेरा पासवर्ड का इशू है। आप चालू करो, आपका स्पीड विदाउट है। शुरू करो, कोई जरूरत नहीं, बोल दो आपका। अब ये लगा के देखो, लग जाता है।
आपका ये रहने दीजिए स्क्रीन यहाँ से
आप मेरे को दे दीजिए, मैं उसको वहीं यहीं चला लेता
स्क्रीन तो मिटेगा ऐसे रहने दीजिए।
हूँ। परफेक्ट चल रहा है।
आप यहाँ से दीजिए आपका स्क्रीन दिखेगा
Hello, good evening, friends. First of all, I want to say thanks कि बहुत short notice पे GST PAMs I came here just daily से meeting के लिए, but they allow me some time to give the demo about the product. So, sir, I am basically co-founder and the CEO of the Taxo.online, and we come with the advanced solution on the GST, where you also find the case laws, all the case laws. I think sir बैठे थे अभी सुनील जोशी जी भी रहा. He also searched for the some cases. You find the very beautiful library of the case laws, and the also beautiful tools for the search of the notification circulars. And we are also providing the master notification like in the rates. There the 20-25 times changes are comes to find the as updated
according to the period with an updated notification. And all the repository part, be it act, interlink with the rules interlink with the notification circulars, and in each and every section, all the 174 sections on GST has the commentary, all have the FAQs of the department, all have the illustrations, and all have the notification circulars. And other than this, we are providing the case studies on the 26 sectors. और जो भी आपको जीएसटी रिलेटेड कोई भी चीज लगती है, मेरा यह मानना है कि हमारी कोशिश करिए वो आपको कहीं भी मिसिंग ना हो, और आप हमारा टेस्ट भी ले सकते हैं. तो यू फाइंड द ईच एंड एवरीथिंग. पास या फेल इज नॉट द ऑब्जेक्टिव, पर थिंक इज दैट कि अगर हमारी कोई कमी भी होगी तो ऑन द बेसिस ऑफ फीडबैक वी विल इंप्रूव फर्दर. दिस इज द ऑब्जेक्टिव. मैं आपको एक छोटा सा डेमो देता हूँ. दिस इज द होम स्क्रीन जो अभी दिख रही थी. आई थिंक थोड़ा सा ग्लिच आ रहा है तो लैपटॉप्स का. तो मैं आपको बताना चाहूंगा जीएसटी से रिलेटेड आपका जो भी होगा, हमारा सर सॉल्यूशन दो तरीके से है. वन भी द सेल्फ पेस्ड लर्निंग का हमारा एप्लीकेशन है, जिसमें आपको पढ़ने से रिलेटेड जितना भी रीडिंग मटेरियल है आपको सारा कुछ एक ही जगह मिलता है. अदर देन दिस, हमने इसमें इंटरेक्शन का प्रोग्राम रखा हुआ, इंटरेक्शन विद द एक्सपर्ट्स. एवरी फ्राइडे वी 5 to 6 वी हैव द सेशंस ऑन द लेटेस्ट नोटिफिकेशन सर्कुलर एंड द जजमेंट ऑन द जीएसटी. वो रहता है. अदर देन दिस कि आपने सेल्फ स्टडी भी किया, डायरेक्टेड विद द एक्सपर्ट, बट आपकी फिर भी बहुत सारी चीजें रहती हैं, डिलीवर रहते हैं, डाउट रहते हैं. जैसे अभी सर के साथ काफी सारे क्वेश्चंस डिस्कस हो रहे थे, होता है. अब सर भी हर टाइम अवेलेबल नहीं होंगे, बट ऑनलाइन सॉल्यूशंस में है कि यू कैन पुट ए क्वेश्चन देयर एंड विद इन 24 वर्किंग आवर्स यू गेट एन आंसर ऑन योर email. So complete, we are trying to give the complete comprehensive solution on the GST. Now I show you the demo. That's about the product. तो मैं आगे जैसे फर्दर चलता हूं सर, तो मैं आपको फ्री वाला कंटेंट नहीं दिखा रहा हूं. आई विल शो यू द कंटेंट जो हमारा आपके लॉगिन्स के बाद में अवेलेबल है. तो सर आप देख रहे हैं कि ऑल जीएसटी एक्ट रूल्स नोटिफिकेशन सब कुछ आपको साइलो में पढ़ने के लिए मिल रहा है. यहाँ पर भी आप साइलो में पढ़ सकते हैं, लेकिन जो मेजर इंपॉर्टेंट चीज होती है जो आप लोगों को सबसे ज्यादा जरूरत पड़ती है इज द केस लॉस और इज द नोटिफिकेशन सर्कुलर्स. तो मैं उसी पे ज्यादा एम्फेसाइज करूंगा और किसी चीज पे ज्यादा एम्फेसाइज नहीं करूंगा. बाकी क्योंकि काफी रिपोजिटरी पार्ट है वो तो सब जगह मिल जाता है. जो हमारा खुद का पार्ट है कमेंट्री, सर ने देगा ही इम्प्रेस विद द कमेंट्रीज और इलस्ट्रेशंस और केस स्टडी, वो भी आपको मिलेगा. मैं जस्ट आपको केस लॉ लाइब्रेरी सबसे पहले दिखाता हूँ. तो दिस इज आवर केस लॉ लाइब्रेरी. अभी जैसे 16(4) की ही बात हो रही थी. तो जैसे ही हम 16(4) डालते हैं सर, तो सर आप देखेंगे 16(4) से रिलेटेड ऑल जजमेंट्स आर हेयर. अभी जैसे सर मेरे से बात कर रहे थे, लाइक अभी सर ने एक केस की अभी मेरे से बात करी थी. क्या नाम था सर जो? हाँ जी, हाँ जी. तो दस ही सेइंग कि अभी एक केस डिस्कशन होने वाला है, इज दिस अवेलेबल और नॉट. तो लाइव सर ने चेक किया एंड इमीडिएटली उन्होंने कहा यार मेरे लिए तो इमीडिएटली सब्सक्राइब कर दीजिए. जो केस आप भी डिस्कस कर रहे थे इज अवेलेबल है. तो कोशिश करी गई है कि ऑल केस लॉज आपको यहाँ पर रिपोजिटरी में दिए जाए विद द कंप्लीट डिटेलिंग के साथ. और कोशिश होती है कोई भी नोटिफिकेशन सर्कुलर आए उसको 24 से 48 आवर्स में उसको सिस्टम में अपडेट कर दिया जाए. तो केस लॉज की सर लाइब्रेरी भी अवेलेबल है. अगर आप दूसरा, हमने केस लॉज को एक अलग तरीके से भी दिखाने की कोशिश करी है. आप पर्टिकुलर कोई सेक्शंस के केस लॉज पढ़ना चाहते हैं, लाइक आप आईटीसी पे केस लॉज पढ़ना चाहते हैं या आप सप्लाई पे रिलेटेड कोई केस लॉज पढ़ना चाहते हैं, लाइक मैं आपको आईटीसी का ही दिखाता हूँ सर. सेक्शन 16 पे आ जाता हूँ, नॉट टेकिंग टू मच ऑफ टाइम. आप यहाँ पर केस लॉस पे जाते हैं तो आपको सर यहाँ पे एन नंबर ऑफ केसेस जो हाई कोर्ट सुप्रीम कोर्ट के मेजर माइलस्टोन जजमेंट्स हैं वो आपको सिलेक्टेड यहाँ पर दिए गए अलोंग विद द कॉपी ऑफ द जजमेंट्स. आपको कॉपी ऑफ द ओरिजिनल जजमेंट की आपको कॉपी भी अवेलेबल रहेगी उस, यस सर, पीडीएफ में. इनफैक्ट इसका जो स्कैनर या जो भी अपना कोर्ट का रेफरेंस होगा वो भी उसके ऊपर मेंशन रहने वाला है, जैसे आप ऊपर देख रहे हैं तो मेंशन। थर्ड, मैं आपको केस लॉस का एक तीसरा तरीका बता रहा हूँ। लाइक सम टाइम होता है कि यार मेरे को एक पर्टिकुलर टॉपिक पे कुछ केस लॉस पढ़ने हैं, मैं ईवीएल से रिलेटेड यार मेरे को अच्छे केस लॉज एक साथ देखने के लिए मिल जाए, सर्च वर्च का ऑप्शन मेरे को इतना कुछ याद नहीं आ रहा, तो लाइक ईवीएल पे आपको इस तरह के 37 केसेस मिल जाएंगे, आईटीसी पे आपको 70 केसेस मिल जाएंगे। तो जस्ट क्लिक है, तो थोड़ा सा ग्लिच चल रहा है बट कि आप लोग समझ पा रहे होंगे चीजों को, तो आपको यहीं पर जजमेंट मिल जाता है। और अगेन हाई कोर्ट सुप्रीम कोर्ट पे ही हमारा फोकस है कि वहीं के आपको केसेस दिए जाए, और कोशिश रहती है कि जैसे आपको पूरा डिटेल्ड है जी केस की। एंड अगेन यू कैन आल्सो फाइंड द कॉपी ऑफ द जज, आपको जजमेंट की कॉपी भी वी आर प्रोवाइडिंग। तो सर दिस अबाउट द केस लॉ। केस लॉस लाइब्रेरी से आप सर्च कीजिएगा, इफ यू वांट टू एड ए पर्टिकुलर सेक्शन वाइज, इफ यू वांट टू रीड तो आपको पर्टिकुलर सेक्शन में मिलेगा, इफ यू वांट टू रीड पर्टिकुलर टॉपिक्स तो ऑलमोस्ट 20 टॉपिक्स हमने सेलेक्ट करके दिए हैं, उसमें हमने आपके लिए जो माइलस्टोन जजमेंट वी आर गिविंग यू। एंड नाउ आई आल्सो एंड यू कैन आल्सो सी द ऑल द विंडोज भी ओपन सेपरेटली, इससे आपको बैकवर्ड फॉरवर्ड करने का वो नहीं इशू नहीं आया, और एवरीथिंग यू गॉट इट एट ए वन स्टेज। और सर मैं आगे फर्दर आपको जो बताना चाह रहा था, एक हमारे प्रोडक्ट का जो एक और अच्छा फीचर है सर, कंप्लीट साइट, लाइक अभी बात हो रही थी गुजराती एंड मराठी की, देयर इज द ऑप्शन इफ यू वांट टू कन्वर्ट साइट इनटू एनी लोकल लैंग्वेज, तो विद इन फ्रैक्शन ऑफ सेकंड कंप्लीट साइट गोट कन्वर्टेड इनटू द मराठी। सर जो पीडीएफ है या इमेजेस है वो नहीं है, लेकिन जो उसका क्रक्स लिखा हुआ है एचटीएमएल में वो आपको ट्रांसलेटेड मिलेगा सर। इनफैक्ट आप गुजराती सेलेक्ट करना चाहेंगे तो गुजराती, ऑल रीजनल लैंग्वेजेस आर हियर, पंजाबीज एंड एवरीथिंग इज हियर। So this is the license we bought from the Google for the translations, and so accuracy level भी sir we also checked is almost 99% is accuracy level, because translation always has the some chances, but interpretation जो है आपको you can understand that. And one beautiful thing is that now I will come to the notification circulars. Sir you find the notification circulars in the particular sections जो मैंने आपको दिखाया, but if you want to search any notification circulars, there is a beautiful option, you can search by dates, you can search by the type, and हम notification circular के अलावा we are also providing the orders and everything, we are regulation and everything we are providing. आप किसी भी चीज को चेक करना चाहते हैं तो आप उसको चेक करके सर्च कर सकते हैं। इनफैक्ट इफ यू वांट टू सर्च बाय टॉपिक, आपको ई-वे बिल से रिलेटेड चाहिए, इनवॉइसिंग रिलेटेड, आप टॉपिक को सर्च कर सकते हैं। एंड सर्च नोटिफिकेशन बाय नंबर, if you want to this search by notification, I give you the one small sample. And again all notification circulars हम आपको सर जो we are providing you, हम आपको प्रोवाइड करते हैं इन द एचटीएमएल, उसका पूरा एक समरी रहता है, पूरा एक एचटीएमएल में उसका आपको पूरी की पूरी हम डिटेल भी प्रोवाइड कराते हैं। आप किसी भी नोटिफिकेशन सर्कुलर को सर्च करना चाहें तो यू कैन इजीली सर्च। और ये लास्ट जो है 6 सितंबर को लास्ट नोटिफिकेशन आया था, वी आर ट्राइड कि अपने 24 से विद इन 24 टू 48 आवर इट गॉट अपडेटेड। इनफैक्ट जिस दिन आएगा रिलीज तो उस दिन हो जाएगा, बट आफ्टर द एनालिसिस वेयर दिस इज इंपैक्टेड ऑन विच सेक्शन विच रूल, तो इट्स टेक 24 टू 48 बट इट गेट impacted. Like I open one more notification for you, करते हैं। एंड अच्छा one more thing I forget to tell, if you want to see the copy of this notification, HTML हमने दिया, उसका क्रक्स हमने दिया, you just have to click here. So copy of the notification in the form of the PDF is also available. Only PDF and the picture part is not converted into the regional language, but rest of the site got converted into the this part. And one be the master notification, then I will not take after that too much of time. Sir, सबसे ज्यादा changes comes in the rates, RCM, cess and exemptions. और इसी में मेन लिटिगेशन है, इसी में मेन चैलेंज आ गया 30 डेज के लिए 40 डेज के लिए कोई रेट चेंज हुआ था और समवेयर यू गॉट स्किप्ड। तो क्या होता है आपको 2017 पे देन यू हैव टू बिल्ड अप द कंप्लीट वर्किंग, देन पर्टिकुलर रेट में आपको जाना होता है। सर हाँ मैं सर ईच एंड एवरीथिंग इज द ऑनलाइन, अनलिमिटेड एक्सेस है, आप कहीं भी एक्सेस कर सकते हैं, कोई इसका टाइम का बाउंडेशन नहीं है, कुछ नहीं है। प्राइस इज जो सेल्फ बेस्ड लर्निंग है इज द वेरी नॉमिनल, इज द वी आर ऑफरिंग टू द बार 5,000 रुपीज का प्रोडक्ट है, 5,000 प्लस जीएसटी का. वी आर ऑफरिंग टू द ऑल द मेंबर ऑफ द GSTPAM at a 3,000 plus GST, 40% flat discount. And if you are going with the webinars every month, weekly webinar, then the price is 10,000 plus GST. But we are offering this product at a 6,000 plus GST. तो complete product है. I think सर ने तो पूरा complete half an hour का demo लिया है. तो you get each and everything. I'm not taking too much time, but I can say you get each and everything जो एक practitioner को चाहिए यहाँ मिलती है. और इसके अलावा सेल्फ पेस लर्निंग के बाद आफ्टर वेबिनार इफ यू हैव द एनीथिंग यू कैन आस्क द क्वेरी फ्रॉम अस. आप हमारे से क्वेरी पूछेंगे, यू आल्सो गेट ए आंसर इन योर क्वेरी. आपको 24 आवर्स में आपको आपकी क्वेरी भी रिप्लाई मिल जाएगी. आई थिंक आई विल टेक नाउ रेस्ट एंड थैंक यू वेरी मच फॉर द गिविंग मी द प्रोसीजर टाइम. हाँ, सर का क्वेश्चन था जी, ये मोबाइल ऐप है. तो मोबाइल सर, ये मोबाइल फ्रेंडली है. इसका शॉर्टकट आपके मोबाइल पे क्रिएट हो जाता है. आई विल शो यू कि आप मोबाइल पे इसको एक्सेस कर सकते हैं. सर इसमें ना हमने सर, हाँ, इसमें सर हमने क्या किया है, आपका ये क्वेश्चन था कंटेम्परेरी इश्यूज करके हमने एक इसका सेक्शन बनाया है कि दो ज्यादा टॉपिक्स जो मेजरली आपके लिटिगेशन से रिलेटेड है. हाउ डू यू हैंडल इट. ड्राफ्ट तो क्या होता है सर, आपके पास अवेलेबल भी रहते हैं, उसको आप फाइन ट्यून भी कर लेते हैं. पर लाइक ए अमाउंट पेड अंडर प्रोटेस्ट है या इस तरह का कोई टॉपिक है, हाउ यू हैव टू बी हैंडल एंड कंप्लीट कमेंट्रीज विद द रेफरेंस ऑफ द केस लॉ इज अवेलेबल, जिसमें की टॉपिक्स आपके जो लिटिगेशन रिलेटेड रहते हैं वो आपके रहते हैं. एंड ओवर टीम इज सर, वी आर फ्रॉम द लास्ट 30 years इन द इनडायरेक्ट टैक्स एंड ओवर मेंटरशिप ऑफ दिस प्रोडक्ट इज द सी अतुल कुमार गुप्ता, पास्ट प्रेसिडेंट ऑफ ICI, जो GST में ही प्रैक्टिस करते हैं. तो कंप्लीट प्रोफेशनल्स, लॉयर्स एंड CA ही हमारे इस प्रोडक्ट के पीछे है सर. यस सर, बिल्कुल बिल्कुल रहती है. उसकी अपना समरी भी रहती है, उसका कंप्लीट डिटेल रहती है. जिस तरह से समरी हमारा हर नोटिफिकेशन सर्कुलर में भी आपको समरी मिलेगी. सर सिलेक्टेड एयर्स है. तो जो भी इसको सब्सक्राइब करना चाहता है, मैं अपना नंबर भी रिपीट कर देता हूँ. आई थिंक नेम इज मनोज कपूर. आपका सर कोई क्वेश्चन था, छूट गया, मैं इधर ध्यान चला गया. ठीक है, माई नंबर इज 98. अगर आप नोट करना चाहें, वैसे मैं भी बाहर हूँ, किसी को एक्टिवेशन कराना तो बता दीजिए, मैं हाथ का एक्टिवेशन भी कराता हूँ. 9891. मैं कार्ड शेयर भी कर लूंगा सर. हाँ सर, सर्कुलेट भी कर देंगे. फिर भी नंबर जो नोट करना चाहते हैं 9891005210. आई थिंक थैंक यू वेरी मच एंड प्रेसिडेंट साहब समय देने के लिए. 005210. मनोज कपूर सर.
थैंक यू मनोज जी.
थैंक यू.
ये सॉफ्टवेयर अपने लाइव इधर भी आपने दिया है फ्री ऑफ कॉस्ट, लाइब्रेरी में एक्सेस करने का रहेगा. इधर भी हम वो फ्री ऑफ कॉस्ट आपने को दे रहे, तो किसी बैंक है तो अपने यहाँ पे कमिटमेंट दिया उनके बच्चे. ओके, थैंक यू मनोज जी. आई विल रिक्वेस्ट आदित्य सुरते टू प्रेजेंट द आर्ग्यूमेंट ऑफ टाइम. आदित्य प्लीज. सॉरी,
I know आदित्य सूर्य को आज 2-3 बार हिचकी आया रहेगा. Never mind. I firstly thank the president to chair this session of study circle meeting, second study circle meeting. I thank today's speaker CB Thakar sir. He has been absolutely brilliant as he has always been. So we thank you from the LNR committee, and we thank Taxo for their presentation and offering the software to us. And we lastly, I would like to extend my thanks to all the participants offline and online. And it's a very it's a pleasure for our LNR committee to hold more physical meetings. And I could see there's a good participation in physical as well as online format. So I would request everyone to attend these sessions. There would be study circle meetings every month, so keep visiting. Thank you very much. I would conclude the session with national anthem. I would request everybody to rise for the national anthem. अधिनायक जय हे भारत भाग्य विधाता,
पंजाब सिंध गुजरात मराठा द्राविड उत्तर विंध्य हिमाचल यमुना उच्चल जलधि तरंग तव शुभ नामे तव शुभ आशीष मांगे गाहे तव जय गाथा जन मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 भारत माता की जय।